Hello everyone, I'm Jenna Walmer. I'm a grad student at Westchester University of Pennsylvania in the United States, and today I'll be talking about Rwanda's post-genocide transitional justice, and I look at the International Criminal Tribunal for Rwanda and the Gacaca courts and how they tried cases of rape. In 1994, Rwandans experienced the worst mass atrocity in Rwandan history. In 100 days, the Interahamwe and extremist Hutus brutally murdered approximately 800,000 people. Because of the gravity of this kind, the international community and the Rwandan government decided to take necessary measures to bring justice to the perpetrators. Following the example of the International Criminal Tribunal for the former Yugoslavia that began in 1993, the United Nations established the International Criminal Tribunal for Rwanda, or the ICTR. However, Rwanda also had national and local level courts. This presentation examines the successes and pitfalls of the ICTR and the local Gacaca courts. The thesis is twofold. First, the ICTR provided an adequate mechanism of transitional justice in prosecuting perpetrators of rape. Because of its successes, the ICTR greatly impacted international law's definition and understanding of rape. On the other hand, victims of rape felt that the Gacaca courts did not bring justice. So first, a little bit of cultural context that shows why looking at rape is important separately from other cases during the international tribunals and Gacaca courts. So first, these two quotes. "Truth is not always good to say. And if pain does not have a voice and trauma cannot be spoken, prioritizing speech over silence and assuming that peace building and reconciliation rest primarily on verbalized accounts of the past events leaves the radical potential embedded in silence unexamined." And these two African proverbs really situate why it was difficult for women to speak about the crimes committed against their bodies. Another thing that came up in some of the witnesses' testimonies or survivor testimonies was that Rwandans don't really speak about their bodies. And secondly, in Rwandan culture, there's this importance of community. And so the degradation of women who survived rape also kind of translated to the community. So rape was not only a disgrace of the individual, but the larger context of their community. And then lastly, there's a connection of gender and ethnicity in hierarchy in Rwandan society. So when colonizers came to Rwanda, they put Tutsi women above Hutu women, and they saw them as more beautiful, and this further instigated the hatred between the two groups. And then lastly, the Hutus created their own 10 commandments, and the first 3 of their 10 commandments were about gender. Number 1, Hutu men were forbidden to have relations with a Tutsi woman as a wife, or they would be seen as a traitor. Second, Hutu women are more worthy. They are more conscious of their role as a woman, spouse, and mother. And lastly, Hutu women are to be vigilant and bring their husbands, brothers, and sons back to the path of reason. So it really shows the traditional gender roles of women that were valued in the Hutu community. So now just a little bit of background on the 2 different court systems I look at. The International Criminal Tribunal for Rwanda operated from 1997 to 2012, indicting 93 individuals and sentencing 62. It addressed violations of international law, and it focused on high-level perpetrators. And to be seen as a high-level perpetrator, the accused had to be superior to actual perpetrators. They had to know or have reason to know of the criminal act committed. The accused also had to have effective control over the perpetrators to prevent or punish their crimes. And lastly, the accused did not take measures to prevent or punish their crimes. And this is how the ICTR found high-level perpetrators guilty of said crimes. And then the Gacaca courts is a traditional form of court in African culture, Gacaca means the grass, and it's historically a local method of dispute resolution rooted in indigenous models of justice. And so after the Rwandan genocide, the Gacaca courts were kind of a hybrid with indigenous and traditional model or Western models of justice. So these Gacaca courts operated from 2006 with over 3,000 cases. The goal of this court system was to find truth, peace, justice, healing, forgiveness, and reconciliation within the community. And they tried lower level perpetrators, so homicide, serious attacks without intent to cause death, and crimes against property. So this is my theoretical framework I use to judge the effectiveness of the different court systems. My framework is a mix of scholars Gerald Gahima and Thomas Metz's main objectives for transitional justice, and I focus on the ones that are on the slide. And in this presentation, I parse it down a little bit. So I've discussed accountability. And accountability is seen as determining and apportioning the responsibility of individuals, organizations, and states for past wrongs. So I judge the effectiveness of that. And then I look at how emotions may have changed through the court systems, and that is seen as improving communal relationships through positive cognitive and behavioral adjustments. Then I will look at listening to the victims, which is hearing the stories of the victims specifically before a certain audience and encouraging victims to share, which becomes really important in the Gacaca system. And then I look at rule of law, specifically in the ICTR, and how changing an implementation of legislation occurs after a mass atrocity. And then I also look at forgiveness, specifically in the Gacaca court system, and that is seen as changing a perspective of the wrongdoer through the absence of an inclination to inflict harm or to rebut another's end seeking. So to do my analysis, I use mostly survivor testimony, and then to look at how the rule of law changed, I analyze court documents from the ICTR and their proceedings of the definitions they use to define rape. So first, accountability. So I use the survivors' quotes for this. In the ICTR, one survivor said, "The fact that rape was taken into consideration in the prosecution of Akayesu has had a worldwide impact on the issue of rape of women." And so rape survivors as witnesses to ICTR express gratitude for the international community's accountability towards crimes of rape. But on the other hand, in the Gacaca court, many rape survivors report lack of accountability through the Gacaca system. Marie Odette Kayatesi, a survivor, says, quote, "The men who raped me are walking freely in the streets today and have never been held accountable." And so these survivors quote themes of limited accountability because of limited sentencing of perpetrators or reduced sentencing, and then ultimately being set free from the jails. And then emotions. This is really looking at if there is a positive transformation of emotion or regained dignity in the sorts. So a survivor who was a witness in the Akayesu case and for the ICTR says, quote, "Keeping quiet kills you softly, that a pain in your heart destroys you. But when you open up and you talk about it, the wound gradually gets better." And other survivors who were witnesses in this case expressed their ability to regain dignity and through their ability to testify. However, in the Gacaca court, it's not the same. Here are two survivors' quotes. First, Quote, each time I go to the Gacaca courts, I become very re-traumatized, seeing myself being raped in the forest again. And then the other quote by Mukasakindi, quote, this is not justice. Gacaca courts were supposed to bring justice and reconciliation, but they are bringing more tears than smiles. So you can see the juxtaposition of how emotions either improve or do not improve in the ICTR or the Gacaca courts, respectively. In the Gacaca courts, survivors say that it sometimes re-traumatizes them, so going backwards and improving emotion, and all of the survivor testimonies that I looked at really expressed negative emotion, so no improvement. And so listening to victims. Recall that listening to victims is hearing the victim speak in front of a certain audience that is needed. So in the ICTR, the audience, the perpetrator was there. There were the judges and such. And so, quote, this survivor who was a witness, again in the Akayesu case, says, my friends told me it was important for me to go and testify about what happened to us. It was very important that we go there to make the truth come out. And so in the ICTR provides a platform to tell a story in a formal setting, and it happens before a certain audience in front of the accused and judges alike. However, the Gacaca court, it doesn't give the victims the same justice. The first quote from a survivor, I don't see the point in taking the risk of sharing my testimony there, the Gacaca courts, if it doesn't make a difference. And second, I will never testify at the Gacaca courts because my sister was beaten on her way home from the Gacaca courts where she appeared as a witness. And so this fear of talking, fear of retaliation, knowing that sentencing doesn't occur properly or gives justice to them, this limits the talking of victims, limits the ability to listen. People remain silent and confidential. They're worried about having a fair trial because this is in a community setting. And the survivors also fear corruption in the cases, depending on who is the leader judge in that court system. So next, the rule of law. This specifically applies to the ICTR. And so the ICTR made great strides in improving and changing the rule of law internationally. I've mentioned the case of Akayesu. It happened in 1998, and it really set the precedent for these changes. In this case, the tribunal defined rape as a physical invasion of sexual nature committed on a person under circumstances which are coercive. Sexual violence, which includes rape, is considered to be an act of sexual nature which is committed on a person under circumstances which are coercive. This act must be committed as part of a widespread or systematic attack on a civilian population on certain cataloged discriminatory grounds, namely national, ethnic, political, racial, or religious grounds. So this case really became the foundation for understanding of rape cases in the future. So this case and other cases that use it is more of a conceptual definition, but other cases in the ICTR define it more specifically and mechanically. So in the Gakumbitsi's case of 2004, the court defined rape as any penetration of the victim's vagina by the rapist with his genitals or with any object. And then further in 2006 in the Muvunyi's trial, after analyzing the previous definitions, the chamber concocted their own definition of rape in even more specific terms. So the document states, the offense of rape exists whenever there is sexual penetration of the vagina, anus, or mouth of the victim by the penis of the perpetrator or some other object under circumstances where the victim did not agree to the sexual act or was otherwise not willing to participate. And so these cases show a shift in understanding that differentiates sexual violence from rape. And lastly, one case goes beyond the definition of rape to adding understanding of the issue of consent in these sexual violence and rape trials. So in Renzaho's 2009 case, the chamber took on the issue of addressing the concept of consent. They chose to use a mechanical definition of rape, and then they defined consent, stating, quote, "Consent for this purpose must be given voluntarily and freely, and is addressed within the context of the surrounding circumstances. Force of threat or force or threat of force provides clear evidence of non-consent, but force is not an element per se of rape. Therefore, the chamber recognizes the importance of consent in sexual activity, setting a precedent in international law and for the public at large." And so lastly, one of the tacits I look at was forgiveness, specifically in Gacaca courts. And so this survivor says, "I don't think I can forgive the FAR soldiers or the Interhamwe. I don't want to hear about reconciliation. I accused them in Gacaca courts, including the one who raped me, those who participated in the killings in the church, and those I saw at the roadblock, but now they are being released." So many survivors in their testimony explicitly mention that they cannot forgive because of certain reasons of releasing perpetrators from prison, rapists never asking for forgiveness, lying during trials by the perpetrators, or even perpetrators trying to buy their forgiveness. So some conclusions out of this. The ICTR brought improved rule of law, positive emotional change, active listening to the victims, and accountability to crimes. So these cases set the standard for future transitional justice, and the international community learned lessons of defining rape and consent, listening to encouraging victims of rape stories, and making perpetrators of rape accountable for their crimes. However, the Gacaca courts did not do the same. For instances of crimes other than rape, Gacaca serves as an adequate measure of local level justice through mutual truth-telling and forgiveness. However, for cases of rape, these victims did not have the same experience because of cultural norms that women do not talk about their bodies, and the idea that rape hurts more than the individual. Rape victims felt silenced in their community. They expressed negative feelings towards the transitional justice in providing accountability to the perpetrators, reconciling differences, improving emotions, forgiving the perpetrator, and listening to the victim as provided by the theoretical framework. Thus, the Gacaca courts did not give the victims of rape justice and is an antithesis of the Gacaca court model. And so lastly, there's three main conclusions that the international community, lawyers, and scholars should take away. So first, the definition of rape is twofold. It's both mechanical and conceptual, and the international law needs clear definitions to prosecute crimes adequately and consistently during and after mass atrocities. However, the ICTR set a precedent for future understanding of rape during war and genocide. This momentum should continue, and codification of rape terminology should occur. Second, local level transitional justice mechanisms do not give justice to survivors of rape because of the lack of truth-telling and listening to the victims and the lack of accountability. Therefore, leaders of court systems should take appropriate measures to protect and encourage all voices in local level courts. Lastly, leaders should consider a multi-faceted approach or a mixed system approach with paying certain attention to cultural and historical needs prior to starting the transitional justice process. Although justice should be served in a timely manner, the mechanisms to achieving this must be considered by the nation's and specific communities' needs. When deciding on best fit mechanisms, the type of widespread and systematic crime should be considered. Thank you.